everyone. And thank you, Shannon, for that introduction. Thank you, everybody, for joining us for our webinar today, which will discuss the impact of now, I guess, not so recent USCIS Policy Manual changes on immigrant survivors. So we're going to be talking about the VAWA Self-Petition and 1367 changes to the Policy Manual. My name is Kelly Byrne. I'm a staff attorney here at ASISTA, and I'll turn it to Christina to introduce herself.
Thank you, Kelly. I'm Christina Velez. I'm the Legal and Policy Director here at ASISTA. And even though these are not new anymore, they are rather meaty. So I'm glad to have an opportunity to go through them and hear from y'all what you're seeing.
Yes, definitely. Thank you for that addition. Yeah, we want this to be interactive, so please do let us know in the chat about what you've been hearing in this area. We'd love to hear from you. Next slide. Thank you. So just the OVW disclaimer, this webinar is supported by our OVW Training and Technical Assistance Grant. We thank OVW for their support of our training and TA work. Without their support, today's webinar would not be possible. Also like to thank, just a reminder to folks that opinions, findings, conclusions, and recommendations in today's webinar are ours and do not necessarily reflect the views of the U.S. Department of Justice. Next slide, please. So for our learning objectives, the hope is that by participating in today's session, you will be better able to describe USCIS Policy Manual changes about 1367 and VAWA Self-Petitions, to determine how USCIS may adjudicate certain case types after implementation of the changes, and to adapt your practice to the new requirements. Next slide. So we'll start with VAWA self-petition changes, then we'll take some time for questions and answers. Then Christina will take us through the changes to USCIS's interpretation of 1367. And throughout, we'll be talking about enhancing adjudicators' perception of survivors' credibility. And then we'll end with questions and answers and some takeaways. Next slide, please. So just a reminder that these VAWA self-petition changes were effective on the day they were released, which was December 22nd of 2025, and they applied to petitions that were pending on that date, as well as petitions filed after that. So they are retroactive. Next slide. So we'll start with evidentiary matters, because that's where a lot of the changes came out. So as some of you probably know, there is the any credible evidence standard, and that is a statutory standard, and it applies to the adjudication of VAWA self-petitions, at least for abused children and spouses. Parents, by policy, USCIS applies it to parents, but the statute actually does not. But so USCIS in these updates, they concede that this is a statutory standard, but they've really honed in on the part of the statute that says USCIS has the discretion to determine what evidence is credible. So they're really honing in on the discretionary aspect of the statute. And when they're talking about what evidence is considered credible to USCIS, it has to be both externally and internally consistent, meaning that it's consistent with what is in other sources. So, for example, what is in their systems already about the survivor, as well as internally consistent. So, if the survivor's affidavit, something that the survivor's saying in one part of the affidavit contradicts what is in a different part of the affidavit, that would be considered internally inconsistent. This also says it has to be plausible in order to be credible, and that it also needs to be sufficiently detailed. We at ASISTA have always encouraged practitioners to submit detailed and specific affidavits from survivors and to always submit the best evidence that is available. But that is even more important now with these changes that are really focusing on USCIS's discretion to determine what is credible. About affidavits, which we know are really important in VAWA self-petitions, USCIS has now said that affidavits should generally contain extensive detail about the person writing the affidavit, including their address and their date of birth. Address and their place of birth. So those are, some important safety considerations to think about, particularly if you're having maybe supporting affidavits from folks who don't have lawful status or who have short-term status. So that is just something to think about. I personally have not seen a denial of a self-petition because an affidavit didn't have, the affiant's place of birth and address, but this is just something to keep in mind that this is in their guidance. You'll also see that USCIS focuses a lot on corroboration. So if you truly cannot get corroboration for a certain piece of evidence, that will be a more difficult case to win. That has always been the case, even before this new guidance came out, but it's especially true now. But in some cases, you can push back on the corroboration requirement, which we'll talk about a little bit later. For now, I'll just say that evidence that is detailed and that is specific and that is internally and externally consistent, that can still be credible evidence, even under USCIS's definition, even if it's not corroborated. USCIS has also imposed new requirements on photographic evidence, which we know a lot of folks use in VAWA self-petitions. Now they're saying that the self-petitioner has to identify the photographer and then also when and where that photo was taken. Again, with photos, this isn't necessarily new. Like even before, I had seen in technical assistance some RFEs casting doubt on photographic evidence, saying things like, this just shows that you and your abuser were together at the same place and the same time, not that it's evidence of good faith marriage. So again, not exactly new here, but the fact that they're now codifying this in guidance shows that they're going to be paying more attention to this. So just making sure that your photographic evidence is detailed. Regarding psychological evaluations, which are not required, but some folks use, USCIS is now saying that they want proof that the evaluator is either treating the survivor, so there's like an ongoing therapeutic relationship there, or that they, quote, thoroughly and adequately evaluated the survivor. So, in keeping with this emphasis on detail, the psych evaluation should contain sufficient details, and the evaluator should explain how their professional training and experience led them to any type of diagnosis of the survivor. There's also now a requirement to include the evaluator's CV or their professional qualifications. So just keep that in mind. In terms of if the survivor in the past has submitted a false statement or a fraudulent document, USCIS has said that will undermine the credibility of all of the evidence in the filing, even the evidence that, was not fraudulent. Again, this is not necessarily new. I saw USCIS, make this argument before. But again, the fact that they're putting this in guidance shows that this is something that they're keeping a close eye on. So it's important to be aware of. If this has happened, so that, there's a survivor who has made a false statement in the past, it becomes even more important to try to beef up the credibility of the other parts of the filing. For example, by trying to get corroboration of as much of the survivor's statement as possible. And if you can connect any past false statements to the abuse, that indicates that, or you could argue that means it wasn't a voluntary false statement, right? Because abuse is something that the survivor can't control. And that supports an argument that the false statement doesn't render the survivor less credible because it was not a voluntary choice to make this false statement in the past. It was coerced, it was related to abuse. And then, sort of a Hail Mary argument that folks could make if there's been a prior misrepresentation and there's a credibility issue. You could argue that just the mere fact of there being a prior misrepresentation shouldn't prevent the approval of the self petition. And that's because Congress intended that at least some folks be able to get approved self petitions despite this. And that is evidenced by the fact that for VAWA adjustment, there is a specific waiver of the fraud or misrep ground that is just for VAWA self petitioners. And obviously, you couldn't get VAWA adjustment unless you first had your petition approved. So that shows that Congress intended that at least some VAWA self petitioners would have approved petitions, even if they had made a false statement in the past. Next slide, please. One big change, and one that we have seen folks reporting in on our listserv, and we would also welcome hearing from you all about if this has been happening, is USCIS is now requiring the survivor to submit evidence of termination of the abuser's prior marriages. So, for example, evidence that before the abuser married the survivor, they were divorced, for example. In the prior version of the policy manual, they said should, but now it says must, so it's more of a requirement. If, in many of these cases, probably the survivor won't be able to get primary evidence, that is a divorce decree, for example, or a death certificate, probably because of the abuse. So in those cases, you could consider alternative ways to try to prove termination and then have the survivor explain why they can't access that primary evidence. And you could also include facts in the survivor's affidavit that would support the intended spouse argument. So, for the intended spouse argument, you would need to include some evidence that supports all of the elements of that. So, the first would be that the survivor believed that they married the abuser, like they had that genuine belief. Two, that there was some sort of a marriage ceremony. It doesn't have to be a particular type of ceremony, but some sort of ceremony. Three, that the survivor believed that the abuser was free to marry them, that they had that subjective belief at the time of that ceremony. And four, that the only reason that the marriage between the abuser and the survivor is invalid is because of the abuser's bigamy. And that is in statute, the intended spouse rule. It applies for self-petitioners who are married to abusive USCs as well as abusive LPRs. So because that is statutory, can't be changed without Congress, it does remain an option if USCIS is going to say that they don't think that the abuser was divorced, for example, before they married the survivor. But you would need to make sure that there was some evidence in the filing for those elements. Regarding birth certificates, you'll also see that USCIS is casting doubt on them if they are not registered contemporaneously with the birth. And we know that, this does sometimes happen. And, obviously, if there's a case where it's a parent or a child self-petitioner, that birth certificate is going to be important to establishing that relationship. USCIS has said that in these late registration cases, it's not going to be an auto bar to establishing a relationship, but they're going to look at it, with a little bit more skepticism. So if you have a case like this, do try to get secondary evidence, like hospital birth records, for example, or like a baptismal certificate, and also have the survivor explain why, to the best of their knowledge, the birth was registered late, and see if maybe other people with knowledge of the birth could include affidavits. Next slide. So battery or extreme cruelty. One of the big changes here is that USCIS is saying now that the abuser must have been a USC or an LPR at the time of the abuse. USCIS had not taken a position on this before. Their justification for this new position is a BIA decision that is in your materials called a matter of LLP. And that decision held that the abuser in a VAWA cancellation case, so a completely different type of relief, in a VAWA cancellation case, must have been a U.S. citizen or lawful permanent resident at the time of the abuse. USCIS didn't offer any reasoning for why LLP should apply here because, especially given that the self-petition and cancellation statutes, their structure is very different. The difference in those structures and this lack of explanation could be potentially avenues to challenge this interpretation in another forum. But in the meantime, USCIS and almost certainly the Administrative Appeals Office are going to take this position. So it's important to keep in mind when discussing with a survivor the risks and benefits of filing a self-petition if the abuser did not have that status at the time of the abuse. The policy manual also appears to apply a stricter definition of battery or extreme cruelty. So when talking about battery, it's a little bit confusing because they mention, the definition that many of us are familiar with from, like torts, like offense, touching a person without their consent. But then they also mention these definitions that involve like repeated blows, right? So that would seem to require something a little bit more. So it's a little bit confusing. Sorry about that. It's a little bit confusing exactly what they're trying to say here, but I do think that there's a potential that they're applying a stricter definition of battery. Regarding extreme cruelty, they also go back to the dictionary. They mention a definition of extreme that includes this language about to the utmost possible degree. So again, they seem to be saying that there is a stricter definition of this term extreme. And USCIS also deleted from the policy manual a list of examples of what could be considered extreme cruelty. And one of those was, for example, making immigration related threats to the survivor. So USCIS has deleted a lot of those examples. Not to say that those wouldn't be extreme cruelty. Like, I think there is still an argument that it would be because even USCIS is still focusing on when they're looking at is this extreme cruelty, the question is the abuser trying to attain compliance or control over the self petitioner? So I think, arguably, immigration threats could still be extreme cruelty if you can show that the intent was to control the self petitioner by making those threats. But you're going to have to make that connection a lot more explicit, perhaps, than in the past. And then the other takeaway from this is that USCIS is moving away from survivor centered adjudication practices in these cases. We can no longer assume that VAWA adjudicators will have knowledge of domestic violence dynamics. So it's going to be really important to include materials on DV dynamics, even if they're at the 101 level. Like, for example, the power and control wheel. You might want to start including that with your filings. There's a really good resource called the Learning Community that I've linked in your materials that also has a lot of good materials on this. So just make sure that you're doing that in all of your cases, I would say, but especially if they include primarily non-physical forms of abuse. You might also want to include detailed letters of support from domestic violence advocates if the survivor worked with an advocate, and that making sure that those letters include specific information about instances of abuse, and then also an explanation from the advocate of why they think that this is domestic violence based on their training and experience, particularly when the instances are not arising to physical abuse that we all would understand are domestic violence, but perhaps a USCIS adjudicator would not. So that's where it's really helpful to get that expert opinion from advocates who see this day in and day out and are able to explain why they think that is domestic violence. You might also consider including research articles or maybe expert affidavits from folks who have experience with what domestic violence might look like in particular communities, such as like the LGBTQ plus community, for example. Next slide, please. Joint residence. I would say this change is perhaps the most significant because it's a complete 180 from how USCIS had interpreted this for the past few years. So, under the new policy, which was also the pre-2022 policy, under this new policy, the survivor must have lived with the abuser during the qualifying relationship. So, for example, that would mean that they would have needed to have lived with the abuser during the marriage. Litigation was filed against USCIS in a few different cases regarding their when this was the policy before 2022, and it may be susceptible to, someone might litigate again. If that's the case, we will certainly inform folks of that. There also may be arguments that it shouldn't be a retroactive change since it is such a substantial change to the agency's previous interpretation, and folks who applied between February of 2022 and December of 2022 would have relied on that old interpretation. All that said, though, USCIS and the Administrative Appeals Office are going to say, regardless, that this is the policy and that it can be applied retroactively. So important to keep that in mind. If you do have a client who is denied because of this policy and is later NTA'd, They might have VAWA cancellation as an option because VAWA cancellation actually doesn't require any joint residence, let alone joint residence during the qualifying relationship. Next slide. Good moral character. So USCIS has said in these updates that conduct that resulted in mandatory detention could be a negative factor in the GM's determination. So not that it will definitely bar good moral character necessarily, but that it would be a negative factor. And they don't distinguish between criminal and non-criminal basis for mandatory detention. And we know that the BIA has said that, folks who enter without inspection are subject to mandatory detention. So that's an example of a non-criminal ground that, under the letter of these policy changes, could be considered a negative factor in the good moral character determination. I personally have not seen this yet in a VAWA self-petition adjudication. Would be interested in hearing from you all to see if you have seen this, but it is something to keep an eye out for. USCIS has also noted that not disclosing a criminal history, even if it's not material to self-petition eligibility. So, for example, someone had an arrest that never resulted in a conviction. So it wouldn't, and it had nothing to do with, reason to believe drug trafficker or anything like that. Like it wouldn't be a bar to good moral character, wouldn't affect eligibility. USCIS is saying that if you don't disclose that, it's still going to be a negative factor for good moral character. And that also it could cast doubt on the credibility of the entire self-petition. So important for folks to disclose the entire extent of their criminal history, even though the form does not ask about it, and even if it is not material to their eligibility. It's always been the case that USCIS can look at acts outside of the 3-year period immediately before filing the self-petition. But in here, they're really emphasizing that they can do that they can look at acts outside of that 3-year period. And they're also saying that the passage of time by itself may not be enough to demonstrate good moral character, even if the acts are outside of that 3-year period. And they say that factors to consider in cases where there are those acts that are more than 3 years old include rehabilitation and the severity of past conduct. So those, that makes sense, but they did remove favorable language that talked about adjudicators having to consider all of the evidence when determining whether a person had good moral character because of a past bad act outside of the 3 years. So they used to say, you have to look at all of the evidence. Now they've removed that. That said, if the past acts were related to abuse or trauma, or if the survivor has been rehabilitated and there's evidence of that, you could argue that these acts are not relevant to the survivor's present good moral character, and that therefore they should not be a bar to establishing good moral character. Next slide. Some other changes. So USCIS has said that it may deny a VAWA self-petition without first issuing an RFE or a NOID. And that makes it really important to include multiple pieces of credible evidence for each VAWA element at the time you file, rather than relying on being able to supplement later on. We recognize, obviously sometimes you have to supplement, like if you're on a deadline, but in general, if at all possible, really important to file well-supported petitions at the outset and not rely on the ability to supplement it later on. And that's especially important in light of the NTA policy that if a VAWA self-petition is denied and the survivor does not have lawful presence, that they will be NTA'd. Another change that we have seen come out recently is that it now appears that field office employees who are conducting I-485 interviews, so VAWA adjustment interviews, are permitted, or at least USCIS policy would say, that they're permitted to ask questions about the abuse. So in the prior version of the policy manual, there was language saying that those folks should not be asking about the abuse because, the interview is about the 485, not about the I-360. That language has been removed, suggesting that USCIS's position is that those officers can ask questions about the abuse. So this is something that it's important to prepare survivors for the fact that this might happen. A couple things that you could do if the survivor is seeing a therapist who, has diagnosed them with, for example, PTSD, and would be willing to write something saying that having to talk about the abuse would cause the survivor to be re-traumatized, that is something you could bring to the interview and use to ask them, not to ask these questions about the abuse because it would re-traumatize the survivor. Another option is that if the field office employee says that they're going to revoke the self-petition, for example, based on something that the survivor says in the interview, you can point them to the fact that the regulations, which they do have to follow, generally require a notice of intent to revoke and an opportunity to respond. So they should not just be able to revoke the self-petition on the spot without any notice. I'm going to put that regulation in the chat box. Sorry, my copy paste wasn't working. So I would bring that citation with you to every interview and be prepared to use it if needed. And if the officer, continues to insist on revoking on the spot, definitely ask to speak to a supervisor and be sure to document the interaction. Next slide, please. So now we're going to do a hypothetical. So we have Devika. Devika is entered the United States without inspection, and she is married to an abusive U.S. citizen, Paul, and they share a 4-month-old child, Tyler. Paul told Devika real mother's nurse and don't work, and that he would have her deported if she tried to get a job. Devika has milk supply issues, but Paul refused to buy formula for Tyler or give Devika money for formula. Desperate to feed Tyler, Devika shoplifted formula while Paul was at work. She was arrested, but the case was recently dismissed on speedy trial grounds. So the questions are, how might the arrest impact good moral character, and how would you discuss this with Devika? So I'll give folks a minute or two to pop their thoughts in the chat. And Christina, if you have any thoughts, no pressure, but I saw you come back on camera. Let me know.
Just decided to join in the conversation. Let's see if any of our attendees want to get us started. Okay. Awkward pause over. Okay. One of the things that caught my eye was the arrest for shoplifting, or potentially for shoplifting, and that being a new basis for mandatory detention after the enactment of the Lake and Riley Act.
Right, exactly. And will USCIS say, even though this didn't result in a conviction, so it couldn't, there's no indication there was a valid admission here. So it couldn't be a statutory bar to good moral character, but yeah, will they say that this negatively affects good moral character because it could, she could have been subject to mandatory detention under Lake and Riley, even though she was not convicted, because Lake and Riley just applies to just, arrests or charges. That makes a lot of sense to me. You could respond that, being really technical, the language in the policy manual is, resulted in mandatory detention, not just subject to. And there's no indication here that Devika was actually, put into removal proceedings and then mandatorily detained. A CIS probably won't be too thrilled with that argument, but you could make it. And then I also see Alvira, I'm sorry if I'm pronouncing that wrong, affects her good moral character, but did it to feed her child, explain the situation. Right, exactly. So making sure that you're including those mitigating factors. I think there's an argument that this, that all of this is tied to the abuse that, Paul has controlled Devika by, not allowing her to work. Said that she would, have her deported if she didn't work. That sounds a lot, or if she did work, that sounds a lot like controlling behavior to me, an attempt to attain compliance over her through these deportation threats. There's also this, these statements that he's made about, how she's choosing to feed her child, which, you might want to go into a little bit more detail, but could be extreme cruelty in this situation, especially if, Devika, she has these supply issues. Maybe that's caused some postpartum depression or other negative impacts on her mental health. And him saying this is, exacerbating that. That could be an example of extreme cruelty. And then,
Well, another a
yeah,
good reason to really dig into the circumstances behind this with her.
right. Exactly. Exactly.
And
And
I wanted to just add that in addition to the technical argument that you were suggesting earlier about the language pertaining to mandatory detention and the policy manual update, also that it notes that, it's a sort of a factor, but it's not conclusive, right? And for all these other reasons that you're bringing out, it should not be
right.
conclusive.
Exactly. Exactly. And I really like that argument that it's not a bar, it's just a factor. And, it should be a balancing test. And there's all these other positive factors on the other side. You could also argue that there's really ample evidence in many places in the INA that Congress's intent is that folks with criminal histories that are related to abuse should be treated more leniently. That comes out in a few places. There is the VAWA Self-Petition good moral character waiver for, waivable acts or convictions that are related to the abuse. Oddly enough, this wouldn't be covered by that because it's not actually an act or conviction that's waivable. Maybe that shows that this shouldn't be an issue, but anyway. So there's that waiver. There's the VAWA cancellation good moral character waiver that's similar for acts that are connected to the abuse and that don't otherwise bar cancellation. There's a waiver there. And then there's a deportation ground waiver for if someone would be deportable for a domestic violence offense, they can get a waiver of that if they can show that there was a connection to abuse. So the fact that all of these provisions exist shows that there's this intention that folks with these convictions that are related to abuse or arrests should be treated more leniently. So that's an argument you could make once you've made that statement about the connection to the abuse. That said, though, still going to be important to provide evidence of positive equities because USCIS's interpretation is that good moral character is a discretionary determination, and discretion is tightening across the board right now, which I'm sure, I don't need to tell you all that. I'm sure you already know. So important to not just rely on the connection to the abuse being enough, but also bring in those other factors that show why Devika is a good neighbor and why she's deserving of favorable discretion. Next slide, please. We won't spend a ton of time on this because, again, like USCIS, the Administrative Appeals Office are not going to buy these arguments because they've already put them in the policy manual. But this is just, if a person were to bring this to another forum, these could be potentially arguments that they would bring. So this is the test that the Board of Immigration Appeals uses for deciding whether an agency rule should be applied retroactively. And for an example of how they have actually applied these rules in practice, you could take a look at the decision that came out on 237A1H waivers, a matter of Forjo, and that is in your materials, so you don't have to go look it up. It's in your materials. That decision actually applied these factors favorably, and the BIA decided not to apply their new interpretation retroactively. So you could take a look at that decision to see, how would these factors be applied? And you could use somebody, if they were to challenge this in another forum, could use some of those arguments. But again, remember that USCIS is not going to actually accept these, so won't spend a ton of time on them. Next slide, please. So, practice tips again, cannot stress how important it's going to be to start submitting evidence about domestic violence dynamics and then making arguments about them in your cover letters and pointing to where in the evidence those particular dynamics show up. So, for example, in the survivor's statement, like which paragraphs pertain to these different parts of the power of control wheel, like getting that granular because again, we can no longer assume that adjudicators understand domestic violence dynamics. Corroboration is going to be important when possible because it helps enhance credibility. Even if you can corroborate small things, like if the survivor says they were at the doctor on a certain day and you have the medical records to show that, yes, they were at the doctor on that day, that can be helpful because it helps enhance the credibility of other things that the survivor said that maybe cannot be corroborated. For example, an account of an abusive incident that the survivor never reported to the police. If you have other examples of corroboration throughout the self-petition, that helps enhance credibility. If you can't obtain corroboration, which, sometimes you can't, the survivor should explain why in their declaration. And then you could argue in your cover letter that corroboration should not be a bright line requirement because that is ultra vires to the statute. Like the statute doesn't require corroboration, and that it's contrary to the congressional intent, which is of the any credible evidence standard, which is to allow survivors who might lack extensive documentation to apply for relief independently of their abuser. Also, be sure you're reviewing filings for consistency. This is something that we've always encouraged, but it's even more important now since inconsistencies will affect credibility of other pieces of evidence. And if there are any inconsistencies, the survivor should acknowledge them and explain them in their declaration. And on the theme of consistency, I recognize that this is difficult for a couple reasons with FOIAs, because first of all, we know that they're being rejected sometimes when you put in the attorney's address, and then also that sometimes they come back with very extensive redactions. But to the extent you can file for a FOIA and to the extent you can get a sense of what has been filed previously, know what was filed previously, especially if like the survivor says, oh, I did file for a green card. And that's because if the survivor says something now that is inconsistent with something that's in their A file and there is no explanation of that inconsistency, that is going to affect the survivor's credibility. So important, if at all possible, to go in, eyes wide open, knowing what was filed before. Briefing the reasons behind the any credible evidence standard, that is also going to be important because in the prior version of the policy manual, there was actually some language about why this standard existed and what was the congressional intent behind it. That language has been deleted, and we can no longer assume that adjudicators will even know why the any credible evidence standard was created or the legislative history behind it. There is some helpful legislative history on that topic that you can find on the website for the National Immigrant Women's Advocacy Project, which I will put their website in the chat. That's a good place to start for legislative history. And then again, affidavits should be detailed. So not even, just what happened, but what was the specific words or actions, if the survivor can remember, what was the context? How did this affect you? And if the survivor has difficulty remembering certain things, is there evidence you can present of maybe a diagnosis that affects memory? And then for affidavits from other people, important that they don't just contain legal conclusions. So, like, she was a victim of domestic violence. That's not going to be as effective as an affidavit that says something like her husband hit her when he didn't like her cooking and he didn't let her go out alone and said that if she left him, he would have her deported. And while this was happening, I saw that she was really distant. And when I did get to see her, I saw that she lost weight. That doesn't just have the legal conclusion, it explains, what happened and what the impact was on the survivor. And then in terms of supplementing pending cases, since you have to show now that the joint residence was during the marriage, for example, and that at least some of the battery or extreme cruelty occurred when the abuser was a U.S. citizen or LPR, make sure that you have sufficient temporal evidence to connect these things. So not only that the joint residence happened, but that it happened during the marriage. And if the case is pending, you might consider supplementing with that evidence. When supplementing, always be sure to put your I-360 receipt notice on top and be as clear as possible to the people in the mailroom that this is in fact a supplement and not a new filing. And then finally, if there's any good moral character concerns, be sure to include copious evidence of positive equities and, if applicable, a connection to the abuse. We can't assume, unfortunately, that the passage of time alone or a connection to the abuse alone is going to be enough to establish good moral character. Next slide. Okay, and then thank you, Christina, for pointing out we also have some legislative history on our website as well. Do folks have any questions so far? So I guess for the sake of time, we'll move on to Christina's portion now.
Thank you, Kelly. And just a reminder for folks, there is a Q&A box also available in this webinar. So feel free to drop your questions in there and either they'll get answered or in writing or we'll address them at the end of this portion. So go ahead. But now we're turning to the 1367 Policy Manual updates, which as I shared the VAWA PM updates practice alert that we did in February, which I'm sure is also in your materials here in the chat, is the 1367 version of that. Like the VAWA Policy Manual updates, these were also made effective as of the day of their release, December 22nd. To all pending and newly filed applications. Let's go to the next slide. So before we really dig into these policy manual changes, I wanted to talk a little bit about when this came into being, when the 1367 confidentiality protections came into being. And they were enacted first in 1996 as part of IRA-IRA, and then they were updated in 2006 to include references to U&T visas in order to protect the confidentiality of survivor-provided information and protect survivor applicants from interference with their cases from abusers or traffickers or perpetrators. And so it's been applied much more broadly than the text of the statute. And you can see here on the slide what the statute actually says, and we'll talk about a little bit more. It is actually quite difficult to apply as written, but the prior guidance for implementing this section is in this memo that I'm going to throw in the chat. Also from 1997 by Paul Virtue, that is also on our website along with other legislative history. And the conclusions made in that memo are that the prior interpretation or application of these protections are very consistent with the aims of and the goals of the VAWA statute. But as written, 1367 encompasses two main provisions that apply to all protected persons, meaning those who have filed UT or VAWA-related applications. The first section is the prohibition against the use of information furnished by an abuser or perpetrator or trafficker to make an adverse determination of the non-citizen's inadmissibility or deportability, subject to an exception where the protected non-citizen has been convicted of certain crimes, which we'll talk about that part in a second. The second protection or provision of 1367 is the prohibition against the disclosure of information referring to the protected person to anyone outside of DHS, DOJ, or the Department of State, except in some limited circumstances for the purpose of a legitimate law enforcement action. Previously, USCIS had applied 1367, I think as many of you know, to like broadly prohibit reliance on abuser provided information, so that any information provided by an abuser or a perpetrator was viewed as inherently suspect for like all evidentiary purposes. And USCIS was required to obtain quote unquote independent corroborative information from an unrelated and not prohibited source before making an adverse finding, again, general finding based on that evidence. The policy manual changes that are most significant here apply to that language, that first provision, the prohibited source provision. So in these updates, USCIS announces an intention to apply the provision as written, which is to say far more narrowly than the sort of broad, inherently suspect approach. So I suspect this, again, was not previously done quite so literally because it's really difficult to implement in that way. And so my concern is that it will just lead, it's just the sort of the major impact of this change will be to narrow, or rather not narrow, but the major impact of this is to make abuser provided information carry the same weight as any other information that comes into USCIS for the purpose of adjudicating a case. So, but survivors who applied for VAWA under that broader interpretation and are adversely affected, maybe by detrimental reliance on this change in policy, may want to also put forward retroactivity arguments, which, as Kelly correctly noted earlier, will not likely see success at USCIS in the event of an adverse decision, but might be worthwhile speaking to a litigator about. So we're not going to talk a lot about the non-disclosure provision. So I do want to note here, at least, that DHS has always interpreted the non-disclosure provision to allow for the different subcomponents of DHS to share information about 1367 covered applications or people. So meaning that USCIS has always been able to disclose that information for ICE, to ICE, but maybe there were other forms of guidance that instructed ICE to not take enforcement action based on any information contained in these 1367 protected applications. And so as that changes, the information sharing that has always been allowed will have a different impact. Let's go to the next slide. So again, what's significant about this new 1367 guidance is that it no longer reflects the view that information provided by an abuser is inherently suspect, except when determining inadmissibility and deportability, which, as we know, is not really a central determination of eligibility for survivor-based immigration remedies. So what this means is that when it comes to the elements of relief, such as good faith marriage, that don't have to do with admissibility or removability, but are really like necessary elements of relief, right? Abuser provided information can come in. And the policy manual change says that adjudicators can consider that information without requiring or seeking independent corroborating evidence. So what do we do with that? So the policy manual does say that this kind of information, this abuser provided information, should be evaluated using the established practices for determining information's credibility. Kelly talked about some of this, didn't she, in her section? Some of the VAWA policy manual changes, the changes to that chapter of the policy manual, talk about applying what sound like maybe to my ears quite stringent standards for evaluating the credibility of evidence, testimonial evidence provided by survivors who are seeking immigration relief. I would argue that the same standards, at the very least, should apply to abuser provided information when determining their credibility. So this includes, of course, considering that the motivation of the source, the reliability and credibility of the statement in the context of all the other evidence in the record, inconsistencies, and other evidence, that other methods for investigating credibility or determining credibility that Kelly went through. So the policy manual also states that officers retain the discretion to corroborate statements by third-party sources on a case-by-case basis. As it says that means that you can advocate for that. Filers who receive RFEs and NOIDs or decisions relying on derogatory information can also cite this language back to USCIS and argue why it would be erroneous for USCIS to rely on that information in their case. I think there is, not sure if we have it here, or maybe it's on the next slide, perhaps. Nope. But there is, I'll find it and put it in the chat. There is a regulation and also policy manual section relating to derogatory information that requires USCIS to provide an opportunity for the applicant to respond, to review and respond to that derogatory information if it is material to the outcome of adjudication. So there is some protection in regulation for the sort of like concept that's, I think, like embedded in due process, like the ideas of due process, that anything that's used against someone they should be offered an opportunity to review and respond to that information. So Kelly, thank you for putting that reg in the chat. I appreciate it. So again, so let's look here. Let's go to the next slide again. Sorry. Okay, so here, because the provision as written, I left that other slide up for a while, but the provision as written also includes this weird exception, right? That allows DHS to consider abuser provided information for inadmissibility purposes. So in the context of the kinds of relief we're talking about, that would be most relevant to waivers for UNT petitioners, the determination of whether a waiver is required, and in some instances, I think it will also come into play in the good moral character determination, of course, as well. So there's an exception here for basically criminalized survivors, allowing abuser provided information to come in if the beneficiary has been convicted of an offense under INA 237A2. Even if that offense has nothing whatsoever to do with the information being provided or the application being filed, or even the beneficiary's propensity for truthfulness, which is how I can see them potentially bringing it up. It's a little weird also because 237A2 specifically relates to deportability, not inadmissibility. And generally, survivors applying for VAWA Self-Petitions or URT relief are usually affirmatively seeking an immigration status, not defending against charges of deportability, except in the VAWA cancellation context. Although nowadays you may see that a lot more often. So let's look a little bit more closely at what offenses are included in 237A2. So if you look at the actual language of the statute, this section covers a lot more than criminal convictions. It includes non-criminal grounds and admissions as well. But for the purposes of this exception, we're looking only at grounds that require convictions. These include CIMTs, aggravated felonies, controlled substance offenses, with the exception of that single offense of simple possession of marijuana, firearm offenses, and crimes of DV, with the caveat that there is that waiver, like Kelly mentioned, that's available for folks with DV-related convictions. I would argue for this waiver to be applied wherever it can be if DHS cites to this exception, which again, it's not clear that they will. We might have to force them to reveal derogatory information before we can get to like their decision tree process and showing how the this section is applied in a particular case. And I haven't heard of this section being applied in a particular case since December 22nd, when these policy manual changes were made. And I suspect because it is very difficult to apply. So another thing is I have italicized some of this language here. I wanted to emphasize that the exception here in 1367 applies only to convictions. And also, if you look at the language, this like a lot of the offenses listed in 237A2 relate to deportability. Again, they after admission. They contain after admission language. So they become effective for deportability reasons after the person has been admitted. So again, we don't know how this provision will be applied or even how it will arise exactly, but I think there is an additional technical argument that can be made here if the person has not been admitted. Essentially, if the person has entered without inspection and then is applying for survivor-based relief and then has maybe one of these grounds and somehow it's coming up in the adjudication of their survivor-based relief and there's abuse of provided information in the record, there might be a technical argument that you can make to sort of impose the same inherently suspect concerns as the rest of the 1367 statute applies. And we used to have a hypo on this, but we took it out because this, again, is very confusing. And I just want to make sure that everyone who attends these trainings has at least seen it once. And so if there's something coming up in a case or you think it might be implicated, I want you to think back to this and maybe get in touch with us so that we can talk about it further. So let's go to the next slide. We're going to talk about what I talked about previously, which is when abuser provided information can come in under this new interpretation or new application of 1367 for purposes unrelated to admissibility, essentially, for purposes related to the elements of an offense, of a benefit request, rather. So here we have Ali and Soraya. Ali is married to Soraya, and Soraya is an abusive LPR. He does not have any convictions. Soraya has frequently threatened to call ICE on Ali. Ali has filed a VAWA self-petition and is worried that USCIS might find that his marriage to Soraya is not in good faith if she calls ICE and says that he only married her for a green card. Are his fears well-founded? We can launch the poll. Thanks, folks, for responding. Okay. I think we can shut down the poll now. We've got 41% responding, and almost everyone said, yes, all these fears are well-founded. And I agree with that because as written, the 1367 allows abuser-provided information to be considered by USCIS without that inherently suspect thumb on the scale. So they only need to evaluate it using these, I guess, whatever the regular standards of credibility are that they use. So there might be more work to be done for representatives who need to sort of diminish the credibility or the impact of a call like this from Soraya in Ali's case. Okay. So it is something to be more concerned about nowadays. Yes. So let's close this up. I'm going to the next slide. So here we're talking a little bit about, oops, I don't know what's going on with my computer. Okay. Now here we are talking about some of the other parts of the 1367 Policy Manual change. That the update also contains changes that I know are super important to practitioners, including that the registration and change of address requirements apply to protected persons. I think that was also underscored in, I think there was a recent final regulation on registration that did not include forms I-918 and 914 as forms that would satisfy the registration requirement. But that regulation did invite additional comment on whether those forms should be included. So it looks like we might see some movement on this. But in the meantime, the policy manual updates that became effective on December 22nd, 2025, say that the registration requirement does apply to all protected persons, meaning all people who are filing VAWA U and T benefits. And that protected persons are not excused also from providing a physical address when required, either in the registration form itself or anywhere else. And we are seeing, unfortunately, we are seeing cases or hearing of cases being denied or rejected for failure to list a physical address in the required field on those forms, including where people have listed confidential or I think it might be a little more complicated for forms that have listed attorney addresses. I'll let Kelly tell me if I'm wrong about that. But certainly for newer applications, we're seeing rejections where a physical address is not completed. At the same time, we are aware that some survivors are in shelters where the physical address information is made confidential by state law. And in those cases, we encourage folks to write specifically in that field that the person's address is confidential, DV shelter as required by state law, and provide, if they have a case manager, which they should if they are residing in a DV shelter, that they provide if you could provide a statement from the case manager on letterhead explaining that the person is in a confidential location. That I think I have not heard of rejections of cases like that, but anything could happen, I guess. But that's my advice if you have cases like that specifically. Also, in the policy manual update, USCIS says that the 1367 protections, such as they are now, and when the person naturalizes, the very slight change from the previous policy manual language, which said that they end there when there is a kind of decision to proceed with revocation of naturalization or denaturalization. Currently, the policy manual says that when they start considering that, or basically when they start investigating someone for denaturalization, that's when the protections come. No, it's the opposite. Sorry. It used to say that where USCIS would pose the protections rather at the point at which it decided to institute denaturalization proceedings. And now it says that, or when they decided to investigate, now it says only at the point at which the denaturalization proceedings are instituted. I'm sorry, I got that mixed up. Thank you for the hearts. I appreciate it. USCIS also in the policy manual updates implied that attorneys or accredited representatives can call the contact center without the non-citizen now. That's one thing that I think probably is welcome in all of this. Let's move on from this slide, shall we? Thanks. All right, so practice tips going over some of what we talked about. We want to recognize now that USCIS will apply this prohibited source provision quite narrowly, more narrowly than it used to. We want to recognize that some criminalized survivors will receive no prohibited source protection. And will also, I think, experience a more difficult time overcoming the negative factors for good moral character as well, as Kelly mentioned. We also want to encourage folks to argue that information provided by abusers, traffickers, and perpetrators is not credible in recognition that information will no longer be viewed as inherently suspect. Once again, brief whatever arguments you've got, including those against retroactivity if it applies. Prepare arguments on why certain criminalized survivors should still be protected by the prohibited source provision because of the language of the statute that they are trying to apply. And be prepared to request derogatory information and to file FOIA requests so that you can see what evidence that USCIS utilized in making its decisions. And we know from our recent roundtable call, right, that FOIAs are taking a lot longer and are coming back with a lot of redactions. And we're looking into that. But we still encourage those FOIAs to be filed. Mhm.
Thanks, Christina. Thank you very much. I see we're at time. I did see, though, a question that came in about calling the contact center, and as the attorney record with the G28 filed, I got rejected by the officer who answered for not having the client online. Do you have any sites for next time this may happen? I do not have a site off the top of my head, but I know it was somewhere in the policy manual. Audrey, if it's okay with you, I will look it up and then get back to you on that because it's a good question.
Yeah, and one thing to really keep in mind about these policy manual changes is that they are throughout the sections that they apply to, especially in particular the VAWA policy manual changes. So when I want to refresh my memory, I look back at actually our advisory because it categorizes the changes and like it puts the changes in different categories and also contains a lot of cites to the policy manual language itself. And Jason, you're right. I'm seeing your chat here that in your experience, a lot of times the derogatory document will be redacted from the FOIA response on privacy grounds. I think this is an emergent issue that we're going to need to work on resolving together. I think there might need to be some litigation on redactions in the FOIAs that people are getting. But especially where you believe that something like that may have happened, I think it might be helpful for your client.
Thank you, Christina. Next slide, please. Sorry, we went a little bit over time. I'll just end with the takeaways. So the first is that the USCIS guidance on the any credible evidence standard makes it critical to include arguments and evidence on domestic violence dynamics and to review your filings for credibility and consistency. That fewer immigrant survivors will be protected by the prohibited source provision, as Christina was saying. So prepare credibility arguments and prepare to address any improper primary aggressor determinations and include copious evidence of positive equities when there is a chance of a good moral character problem. Next slide. And then this is just how to request TA, and an evaluation will pop up at the end of the webinar. Shannon also kindly put it in the chat. We do ask that you fill it out if you have time. We do read your evaluations and we use them to help plan our future trainings. So thank you all for being such a great audience, and thank you for your work, and I hope that you have a good
Thank
rest of
you
your
for your grace. Yes. Thank you, everyone.